that are currently called international commercial courts are not very international. They are very international courts. Now, and that brings me to your first question, the enforcement question. Since international commercial courts, to this date, are purely national courts, the judgments are purely national judgments, and therefore they follow, with regards to enforcement, they follow the exact same rules and regulations as the enforcement of national judgments. So there is virtually, to this date, no difference between the enforcement of purely national judges coming from ordinary, from local courts, and judgments coming from international commercial courts. Having said that, let me point you to one very interesting regulation that is in place in Dubai. Dubai, in order to enhance the enforcement of the judgments of the Dubai International Commercial Courts, has enacted a very interesting rule, and that provides that judgments of the Dubai International Commercial Courts can be turned via another court judgment into an arbitration court. And that will then allow worldwide enforcement of the Dubai judgments with the help of the New York Convention. So that is at least the idea of the Dubai legislature. Whether that actually works in practice and whether other courts will accept that these court decisions are actually arbitral awards is a different question. But that is one way to ensure worldwide recognition that has been followed, is followed in Dubai. Now, that again brings me to your third question, because you asked what is the success of the international commercial courts in the Gulf region. One explanation may be very innovative rules, not just like the one that I just described with regards to enforcement, but I think the real reason is that the courts that have been established in the Gulf region have been set up as completely independent courts. They're completely independent, completely detached from the local judiciary, which is not to be perceived, which are not perceived as a trustworthy environment for the resolution of international disputes. And that is not my assessment, that's the assessment of the jurisdictions in the Gulf regions. So what they basically try to do with their courts, they try to copy successful litigation venues, in particular the London Commercial Court. So if you compare the courts that have been set up in the Gulf region with the London Commercial Court, you find that they are very, very similar. Some of the courts in the Gulf region even apply the English law procedure. English substantive law plays a significant role before the international commercial courts in the Gulf region. And most importantly, I mentioned that courts in the Gulf region, they employ international judges. And when you look where they come from, they all predominantly come from common law countries, and in particular from England. In fact, most of the courts in the Gulf region are staffed with retired English courts and English judges, and apparently these judges enjoy a terrific reputation that makes these courts an attractive place for the resolution of international commercial disputes.
Very interesting indeed. Intriguing notion that a court can turn another court judgment into an arbitration award. Has that ever happened?
Well, I know that this rule exists. I don't know how it's applied in practice, and I don't really know whether other countries accept that these court decisions then are actually arbitration awards. I don't know what the rule is in practice, but that is at least the idea that they have to do by.
Very intriguing notion. Just before I ask for the floor for more questions, on the applicable law, you said that some of these Dubai international courts with the international benches would apply English law. What is the general applicable law in these international?
So generally, all of the international commercial courts apply the general rules of private international law or conflict of laws, and that means that party autonomy plays a huge role. At least when it comes to contractual disputes. So all of the international commercial courts allow parties essentially choose the applicable law. And in the Dubai court, there's a rule in place that basically provides that if the parties have not chosen the applicable law, and under some further conditions, the court will resort to English substantive law. So, but generally, the general rules of private international law include the principle of party autonomy.
That would make it a little bit more attractive. There's just a quick last question from my side before I hand back to the floor. You indicated that only especially some of the courts, only a few cases ended up there through party choice, through the choice of forum clause type of thing. How would the other cases end up there? So how is the best jurisdiction in these international courts?
So there are basically two different models. There are some courts that have to be chosen by the parties, actively chosen by the parties. That goes through for the German International Commercial Chambers, and that goes true for the Netherlands International Courts. So these courts can only become competent through an active party choice. And then there are other international commercial courts, and the French International Chamber in Paris is a case in point, but also Singapore and China are cases in point. They have broad grounds of objective jurisdiction. So for certain commercial transactions, when they come to the court, they will automatically go to the international commercial courts, which are very often not separate courts, but court chambers of existing courts. And then many of these courts are competent generally for all arbitration-related matters. And then, for example, in the case of Singapore and China, other courts within the court system may transfer cases to the international commercial courts. So they may say, well, we have an international commercial dispute here, which should rather be tried in the international commercial court, so they can transfer the case to the court. And that explains why some of the international commercial courts, including Singapore and China and France, they have a large number of cases, but most of them come through transfers from the platform.
Okay, before I ask any further questions, anything else from the floor? We have a couple of minutes left before the authorities tell me that we're exceeding our time. We have literally like 2 minutes on the clock.
Thank you. Good afternoon, everyone. My name is Ibiwe. I'm a final year student, and I'm actually taking intellectual property as an elective, so I'm finding this interesting. I just have 2 questions with regards to what you just said to us. The first being, I noticed that there isn't an international commercial court in Africa. I wanted to know why that is. With particular mention to, as intellectual property doesn't only cover like copyrights and trademarks and everything, it also pertains to traditional knowledge. And I feel in the African continent, we have so much traditional knowledge that is oftentimes exploited by the global community, whether it's through fashion, whether they're using indigenous fabrics that are coming from the African continent, or even hairstyles that they are like terming their own. So there isn't much protection from for the African continent with regards to the global industry or sphere. So I wanted to ask you regarding that. And then my second question is, with these international courts, okay, let's take for instance the ICJ. We all know that if there's disputes between the countries who are part of the United Nations, they can refer the matter to the ICJ. So I want to know, with regards to these international commercial courts, is there an official body that they can all refer to, or there's no stare decisis, if you will? And also, is there like an official body they can report to? And with the ones that have only national judges, how is that binding on everyone else in that region? Yeah.
Well, thank you very much. These are, again, 2 excellent questions, which I'm unable to answer in the time that we have, but I'll try my best. I will start with your second question. There's no official bodies that international commercial courts or international commercial parties can turn to, because international commercial courts are not international courts. They are national courts. They are part of the court system of the host jurisdiction, and in that respect, they are no different from local courts. So there's no official body or a superior court that you could, for example, lodge an appeal to. So that simply doesn't exist. The term international commercial court in that sense is misleading because we are not talking about international courts, we are talking about national courts. First question that you ask is of course much more difficult, and you are absolutely right. There's no international commercial court in Africa, and to my knowledge, there's not even a discussion about setting up an international commercial court. I know that there is some academic debate in South Africa. So South Africa, to my knowledge, the developments surrounding international commercial courts have been taken note of, especially with regards to the Singapore International Commercial Court. But it's my understanding that the policy in South Africa is rather to advance South Africa as a venue for international commercial arbitration. And not so much through the development of international commercial courts. And to my knowledge, that holds true for other European, other African countries as well. Why that is, I don't know. Maybe it is because we have recognized and realized that the benefit that international commercial courts can offer in view of their purely national nature is very limited indeed. And that it's much more beneficial to enhance the general environment for international commercial arbitration. But again, I'm not fully aware of the situation in Africa, but that is my understanding of the state of the here. But maybe you have something to add.
Thank you very much. I think in Africa, there's still a lack of trust in national legal systems, generally speaking, and courts. So Africa is still fighting the battle of getting recognized as a supporter for international commercial arbitration. So that might be part of the explanation. But we have pushed it on out of time. I can see the authority getting antsy around me. So thank you very much, Giza. That was very interesting, and certainly I think hopefully something that we will further explore. Maybe one day you can come back and tell us about the success of the South African international relationship. Thank you so much. We'd like to introduce.
Good afternoon, everyone, and welcome to our second part of the public lecture. Our next presenter is Professor Axel. I'm not going to try and pronounce the name, you will help me with that. But he is a renowned professor of civil law and intellectual property. He is also from Humboldt University in Berlin. He has authored numerous books and edited several books as well. He has written several articles in renowned journals. He has got an impressive resume, just like Professor Gizela. And without wasting much time, I'll just quickly refer to the presentation that is going to make today. So the topic is traditional knowledge, challenges for the global patent system with regards to the origin of biological material. Over to you, Prof.
Thanks a lot, Yuka, for the kind introduction, and thanks to all you people from UWC for having us as guests here. For me, it's the first time in South Africa, and we had the opportunity yesterday to get a tour on your campus at UWC, and I can tell you that my understanding is it's exactly the right place for us to start to be at this university, to have the opportunity to discuss our research topics with you. So I'm glad to be here. Thanks for making this possible to our partners, and I hope that this is the starting point for future cooperation. Speaking after Gisela is always a challenge. Gisela has had a fascinating topic. She was very well prepared with a written manuscript and a very fluent English, so it goes now down a bit. You have to listen to my presentation. No written manuscript, a lower level of English fluency. The thing I can hope for is the attractiveness of the topic, and I already heard that there is interest in intellectual property and traditional knowledge. this is where I want to go now. I'd like to speak the next 25 minutes about traditional knowledge, but specifically about the patent system and the origin of biological materials. So this is only part of the larger debate about traditional knowledge, and you just mentioned other areas where one also has very relevant topics, but I'm focusing on patent law. What I want to do in the next minutes is to start with a South African German case, which is controversial, and not to start with a huge global debate about traditional knowledge and genetic resources, which is on the international agenda now for more than 25 years. There's been academic debate, there has been works within international organizations. You may know that WIPO, the World Intellectual Property Organization, is the organization for IP matters, and if I remember it correctly, they started around the year 2000 in a working group to work on TK and genetic resources, and just came up last year with a treaty that has been adopted. But this will be the final point of my presentation. I've chosen rather to start with a concrete case and speak a bit about substantive patent law standards, which are the substantive law questions to be discussed, and then go into enforcement issues, which are very much the substance of the new WIPO treaty. Okay, let's start with the case. And it's called the Umkaluabo case. I don't know if you are familiar with Umkaluabo, and look in the face of our South African friends. Is it renowned in South Africa or something? Not really. Some of you know it. Not really, okay.
Yeah.
So Umkaluabo is the name for an extract taken from the roots of pelargonium plants. Pelargonium plants are South African geranium plants. Geranium for the German participants is a typical balcony plant. We have in gardens or on balconies, and the extract from these plants, from these pelargonium plants, is used in traditional South African medicine for the treatment of diseases like bronchitis, common cold, but even tuberculosis. So it has quite a tradition in South Africa. That's what I read. You can tell me if this is wrong. In traditional medicine to be used for the illnesses I've just mentioned. Now, this attractiveness of pelargonium root extracts has also come to the awareness of pharmacists and pharmaceutical industries in the north. That's my next slide. This led into a patent application that was handed in the year 2002, and the patent was indeed granted in the year 2007. Now, this is in German, but if you can read it, it's a bit small. The headline is also, heading is also in English. And the patent was granted exactly for a method of producing extracts of pelargonium plants. And it was applied for by a German medium-sized pharmaceutical company, Schwabe. The patent was tested by the patent office, by the European Patent Office, which is responsible for granting patents for 39 states of Europe. It was tested and it was granted 5 years later. And you can already feel, okay, there is a traditional knowledge issue within this patent application. Here's the claims of the patent. So that's the core of the intellectual property right that is granted by the patent office. And if you read this carefully, it's a method for producing an extract from pelargonium plants. And if you read further down, the method, so it's not the product, but it's the method that is protected, is not very revolutionary, but the method of extracting these Umkaluabo extract is something which sounds quite familiar. It's based on an ethanolic solvent, which is used to extract good stuff from roots. So this is not high tech. It looks rather simple. So the patent was granted, and then, that's the next slide, an opposition procedure. was initiated with the European Patent Office. I will explain this in a minute. Opposition proceedings can be initiated by any person in Europe. And you can see here the list of opponents who initiated this opposition proceeding, some competitors, so other pharmaceutical companies, but also among the opponents, the African Center for Biodiversity, for Biosafety, sorry. African Center for Biosafety was among the opponents going to the European Patent Office and arguing that the patent was to be invalidated since the invention was not new and did not involve an inventive step. The opponents were successful and the patent was revoked at the end. And Schwabe did not lodge an appeal, so this first instance proceeding was the final stage of this process. The patent was finally revoked. So in a sense, a positive example that the patent system worked. And from here, I would like to continue with some minutes of the substantive standards of testing those cases. So I'm sure you know, since South Africa shares these principles with Europe, patent to be registered must fulfill certain requirements. It must be a technical invention, it must be novel, and it must involve an inventive step. All this tested against the standard of state-of-the-art or prior art. So it must be novel and inventive as compared to the prior art. The question then is, what is prior art? And this is the, I would say, focal point for substantive law issues with regard to traditional knowledge. And this is defined in Europe in Article 45, paragraph 2, where you can read the state-of-the-art shall be held to comprise everything made available to the public by means of written oral description, by use, or in any other way. What you do not find here is a territorial limitation. So descriptions and use within Europe or in foreign jurisdictions is regarded as state-of-the-art. And at the end, that's the relevant standard why Schwabe lost this case. It was not novelty, but it was the inventive step. And the opposition division of the European Patent Office said, as regards the state-of-the-art, which is the use of Incaduabo within traditional medicine in South Africa, the invention presented by Schwabe did not involve an inventive step. So novelty, they skipped a bit, but with regard to inventive step, they said it was obvious if compared to what we find in the prior art in South Africa. Therefore, Schwabe cannot claim this invention to be its intellectual property. So you see my question at the back of this slide. So if state-of-the-art comprises traditional knowledge used somewhere in the world, where is the problem with traditional knowledge in patent law? So if this is the case, why do we have this debate for 25 years now going on? One answer may be found if you look into other patent law systems, and I've now picked up the US system since this is a very important jurisdiction for pharmaceutical companies as well. Today, that's the novelty standard comprising the standard of state-of-the-art. You find the same concept as in the European patent system. It says a person shall be entitled to a patent unless the claimed invention was patented, described in a printed publication or in public use, and so on, without any territorial limitation. So today, before the US Patent Office, if something has been in use abroad, this is, as we call it, novelty destroyed. So it's state-of-the-art, which at the end prevents a patent to be granted. But if you go down, it's a bit wordy, but I will read the relevant part to you. Before 2002, in the United States, there was a distinction made between state-of-the-art within the US and state-of-the-art abroad. At the time, it read, a person shall be entitled to a patent unless the invention was known or used by others in this country, or patented or described in a printed publication in this or a foreign country. And this is something you find in many older patent laws, a distinction between written prior art, which was novelty destroying wherever it was published in the world, and use of prior art, which was only taken into account if it was within the territory of the patent office. Now, under this provision, indeed, problems may arise with traditional knowledge, which oftentimes is not written or was not written for longer times. And if it was not written and only used within a foreign jurisdiction, the US Patent Office would have to grant the patent at the end, even though something was just picked up from traditional knowledge of another community. So that was the issue. Now, the US law changed rather late this concept, only in 2012 under the Obama jurisdiction. But for example, in Germany, you had the same distinction until 1981. So if you look into older patent laws, you find still this distinction. Today, Europe and US have developed further and accept prior art out of use in foreign jurisdictions. Now, this leads me to a preliminary conclusion. Europe and US recognize use in foreign countries as prior art. So we have experience, and as you have seen in this Umkan case, it works in practice. We have an issue that the threshold for the inventive step is rather low. This is a general problem in patent law. I'm sure you have the same discussion in South Africa as well. So if there is prior art somewhere in the world and the contribution to the technology by the applicant for a patent is very minor, it may still suffice at the end to come to an inventive step. So this is a general problem we have, and this is also of relevancy in the issue of in the question of traditional knowledge, but that's more a general issue. So you can say on a substantive level, the issue of traditional knowledge seems to be solved in Europe and US. However, what remains are enforcement issues. And these are the last 2 points I want to make. First, who can enforce novelty issues based on traditional knowledge? And secondly, how to know that traditional knowledge has been used. And this last point is what is now the main issue of the new WIPO treaty. Now, this first enforcement points, I can be rather short here. Would be interesting to know it's the same in South Africa, I assume, but I don't know it. For opposition proceedings in the European system, we have a very liberal approach. Any person can initiate opposition proceedings before the European Patent Office and can bring revocation claims before state courts later on. So opposition proceedings are only possible in the first 9 months after publication. So this is the cheaper and more efficient way to get rid of an invalid patent, because you can still go to the office, you own the office fees. But if you do not respect the 9 months, maybe because you only at a later stage are aware of the patent, you can still go to national courts and to the new unified patent court. That's something for a different lecture. And bring a claim for revocation of the patent. So even if the patent has been granted 8 years ago, you may still go in front of national courts in a revocation proceeding. And here again, any person can bring those claims. Why is this so liberal? Because the idea is that any person who takes the burden and the costs to go into a revocation proceeding is the representative of public interest, because invalid patents, which are still in the register, are against competition, and it's in the public interest that those patents are invalidated and deleted from the register. But still, this is something which is very special. Everybody can do it. Now, in a traditional knowledge scenario, you can say this is quite an advantageous rule, because non-governmental organizations, donors behind non-governmental organizations, competitors, everybody can bring these claims. And this is something which is of enormous help. There are other political issues where it may be difficult to find the right to stand in court for public interest concerns, not sort of patent law. So this, I think we have indeed a solution for. More complicated is the knowledge issue. How to know that a patent applicant in fact has used traditional knowledge before bringing his invention to the office. In the Umkaloabo case, this question found a very easy answer since Schwabe disclosed as much detail in the description where they found the plans and the methods. Now, this is a citation from the description of the patent. I'm happy to share the slides if you're interested to read it. And if you read into the description, they made transparent that pelargonium has long been used in South Africa as a traditional medicine for certain diseases, how this has been brought to Europe at the end of the 19th century and so on. So in this case, it was disclosed. Why did they disclose? I don't know. I think because Umkaloabo was already known as a famous substance in for pharmacists, so there has not been any chance, I guess, to keep it under the blanket, but it was disclosed. In other cases, we have an issue with disclosure, we have already some rules in place, specifically in Germany, but these rules are not very strict so far. The relevant provision in the German Patent Act is section 35(4)(a), which says, if you read this official translation, which is not very good, it says where an invention is based on biological material of plant or animal origin, or if it uses such material, the application is as a rule to include information on the geographical origin. So it is to include information reads as it would be a strict requirement under patent law, but in the original German text, it's a weaker wording. It says soll, which in Germany is something like you're recommended to do it, but it's not a strict must. And indeed, if you continue to read the provision, there are no sanctions bound for applicants who do not disclose information. So you should do it, but if you don't do it, no sanctions, which means you can still hand in inventions applications without disclosing the sources of the biological material. And in legal practice, it seems that parties do not disclose very often where biological material comes from. So the rule does not really work in practice. In the EPC, we do not even have any rule of this kind. So in the European Patent Convention, which is much more important than the German Patent Act. And if you look into European Union law, the relevant directive, it invites EU member states to implement those such rules, but there is no legal obligation to do so. So to sum this up, for the moment, we do not have enforceable rules on disclosure of traditional knowledge. And now exactly on this point, the new WIPO treaty comes into the picture, which, as I explained you, I take it as the last step of my presentation, not the first step. Now, this WIPO treaty has been adopted in Geneva in May 2024, so not even a year now. And it's the outcome of a diplomatic conference and works that started, as I said, in the early 2000s, so 25 years of negotiations. And this is now where we stand with the WIPO treaty on intellectual property, genetic resources, and associated traditional knowledge. Countries from the southern hemisphere, specifically South Africa, and NGOs have fought for many years for having this important treaty now being in place. However, for the moment, it has not yet entered into force. If I remember correctly, we need, I guess, 15 ratifications for entering the treaty into force, and so far we have a number of signatories, most of them from the African continent. no member states of the European Union so far, and not the European Union itself, which may enter the treaty as well. And we have only one ratification, which is Malawi. So it starts slowly, but I guess that's always the case for treaties of that kind, negotiated in under the umbrella of WIPO. So it may take some years until this treaty will really come into force. Still, it's interesting, and we have ongoing discussions in Germany, in the EU, when and how it should be ratified and how implementation provisions should then look like in the European Union. Now, if you look into the treaty, it has a disclosure requirement, which is now really a strict requirement, where the claimed invention is a patent application based on genetic resources. Each contracting party shall require applicants to disclose the country of origin of the genetic resources, or if it's not known to the applicant, the source of the genetic resource. And then it continues in 3.2, it's more for you to read, that if traditional knowledge is associated with genetic resources, the contracting party shall require applicants to disclose the indigenous people or local community who provided the traditional knowledge. So quite specific disclosure requirement. And then maybe the even more relevant point, what are the sanctions and remedies if parties do not disclose? And this is Article 5. And there was a battle of states and lobbies behind this Article 5 before it found its final wording. The first part of it is the member states shall put in place appropriate, effective, proportionate measures to address the failure. So sanctions are in the authority of the member states. However, if you continue to read, and this will be, I guess, the main points of discussion for the next years, 5.3 says, no contracting party shall revoke, invalidate, or render unenforceable a patent solely on the basis of an applicant's failure to disclose the information specified. So this sounds weak. It sounds like the patent offices cannot invalidate if the sources are not disclosed. But then there is 5.4. It says each contracting party may provide for post-grant sanctions or remedies where there has been fraudulent intent in regard of the disclosure requirement. So at the end, at least if there is fraud, member states may implement post-grant sanctions. And for me, the most interesting word as a lawyer in all of this is the starting point of 5.3, which says subject to Article 5.4. So it means revocation, invalidation, in principle, not allowed. But if there is fraud, then at least in the post-grant stage, there can be really relevant sanctions. For example, I would plead for judgments which render a patent unenforceable to be compliant. But this will be subject to discussion in the next years, and I guess that's really the relevant points. What can you do under the WIPO treaty under these provisions? Yeah, you may now say as lawyers, well, okay, subject to Article 4.5, that's interesting, but Article 5.4 only puts this under a may. So it means Germany or US or European patent organization must not provide post-grant sanctions. Now, all of this is typical for international treaties, which are the outcome of highly controversial issues, but still, I guess it's an important step forward, and it's more than just symbolic legislation. Conclusion. So on a substantive level, I would say the issue of traditional knowledge and biological material seems to be solved in Europe and the US to a large extent. I'm very curious to discuss this with you, whether you concur with me. What remains is the enforcement issue, not the right to stand in court. For this, we have very generous provisions in Europe, and I guess also in the United States. But the knowledge problem is still there, and if the WIPO treaty comes into force, it may be a step forward in the right direction. However, the interpretation of key provisions will be controversial and is something for you as the younger generation of patent lawyers to work on in the next years. That was what I've prepared. Thanks a lot for your attention.
Thank you very much, Professor Axel, for the detailed and interesting presentation. I think all of us, we can agree that the protection of traditional knowledge is very relevant, especially to African countries, and whether the WIPO Treaty adequately protects traditional knowledge as well as genetic resources is something that we're still going to engage on. But before I waste so much time, I would like to take advantage of the fact that we still have 10 minutes or so. So I'm going to ask the person who is seeing the people who are online to also check if there are any questions, because I realized that in the other presentation, we forgot about the people who are attending online. So please check for me if there are people who have got questions online, and then I'm going to open the floor for questions. Any questions, comments regarding the issue of traditional knowledge? I consider this to be one of the most relevant form of IP for African countries. And it's because Africa is endowed with natural resources. We have got biological resources, and we need to ensure that they are protected and that whenever they are used, we benefit from their use. So any comments? Nothing online.
Sorry, what is the discussion in Europe around the WIPO Treaty? Is it a positive? Is there any consideration of them potentially signing? As you said, it's mostly African countries who actually have signed thus far. And I think UK I saw, but also not the US. So do you have any idea what the feeling is towards the WIPO Treaty in those jurisdictions?
So I can tell that during the diplomatic conference and the discussions around the diplomatic conference, the position of the German government very much was to weaken the sanctions. So it was the prime interest of the German government in these debates, and I guess also of the European Commission, to be very clear that invalidation is not mandatory. So invalidation based on failure of disclosure should not be mandatory. That was their main aim, protecting their pharmaceutical companies to this regard. So that was the government side. Even though we had, as you know, the Green Party in the government, but still this was very much led by the Ministry of Justice on the national level, and the European level is against something else. Whereas also we have discussion actors from the non-governmental organizations who pleaded for stricter sanctions. What I heard least was that there is a serious debate of ratifying the agreement, the treatment, since what is the outcome now is really a compromise solution, and it would be strange first to ask for a compromise and at the end not being willing to go that path. So, but I guess it will very much depend on the European Union level, since European Union may enter, and I guess this is where it must happen. And we must change our, I think we must change our legal provisions, which is complicated since the European Patent Convention, based for the European Patent Office by itself, is an international treaty. It's not European Union law. And if there is a mandatory disclosure requirement, there must be some legislative activity on that level. So it's not so easy to implement, but I'm optimistic that it will come.
Thank you very much. I didn't introduce myself earlier. My name is Damilola. I'm a doctoral student at the African Center for Transnational Criminal Justice. Given that if you look at Article 5 sub 4, like you mentioned, it seems to be a bit very weak, especially using may in terms of protection of where there are fraudulent practices as it was mentioned in the article. And like you mentioned in your presentation, it's a compromised treaty solution, so to speak. So my question is, and given the fact that most countries that have signed the treaty or that are state parties are African countries, and given the weak provisions in the WIPO treaty, to what extent can regional mechanism, come into place, maybe from the AU, from the ECOWAS? It seems most Western countries are not taking cogent steps to ratify the treaty, and the Africans that are there, it seems to protect more of Africans. So to what extent can we, apply regional mechanisms to, protect traditional knowledge? Thank you.
Well, I mean, African countries, if they are a member of the WIPO treaty or not, they may implement protection mechanisms for traditional knowledge, be it, I mean, this is a very, let's say, indirect way of protecting traditional knowledge by preventing others from registering patents on traditional knowledge. So this is only an indirect way, the WIPO treaty, but still, African countries can implement those provisions and as such protect traditional knowledge within, for example, South Africa. I guess on a substantive level, if I just had a few moments this morning to read the African Patent Act, if I understand it correctly, in South Africa, mere use of traditional knowledge somewhere in South Africa or elsewhere is novelty destroying. So on a substantive level, the South African Patent Office would have to reject patent application if it is based on traditional knowledge, be it used in South Africa or in Zimbabwe or in another country. Meaning the issue, I guess, also for African countries is more on a procedural level. So how can we force applicants to disclose information about the sources? And what they can do on the regional level, on the national level, is to implement those provisions. And I guess also, since the WIPO treaty now is the international level, it's very important that countries who have a say in the international arena, like South Africa, raise their voice and force international organizations to take concerns seriously that are coming from the Southern Hemisphere. I mean, these pieces of legislation like the WIPO treaty, they are of huge importance for the international setting because, as you know, many African countries adopted or ratified the international conventions in the 1990s for becoming member of WTO. That was the incentive at the time. Many countries entered into the TRIPS agreement and in other agreements, and at the time those agreements were very much biased on the interests of industry of the northern countries. And only after discussions for decades now, the international organizations like WIPO and WTO start to recognize the interests of countries from the Southern Hemisphere. And this very much depends on actors specifically like South Africa, India, and Brazil to raise their voice for other countries who are not so well organized. So I guess it's a long way to go, but the WIPO treaty is a positive signal at the end. Even though I agree with you that the main in 4.5, in 5.4 is something where one could have taken a larger step.
Any more questions?
Afternoon. My name is Abigail. I currently am pursuing an LLM in environmental law. So I was listening to this from that perspective, and I know in the Convention of Biological Diversity, when it comes to traditional knowledge, there are 3 requirements, inclusive of benefit sharing and prior informed consent, as well as mutually agreed grounds. So I wonder why maybe previously agreed upon international agreements weren't considered during this White Book Treaty, because it would seem very valuable, because now the agreement does come across as very weak when there is already existing laws, particularly for biodiversity protection in Africa, but also everywhere else in the world. And I think that this agreement, I don't know if Madagascar is a party.
I don't know. I would have to
Yes,
look
but I remember there was a case on this plant that grows indigenously in Madagascar, and then a US company had used this plant to develop anti-carcinogens that could treat leukemia, but there was no benefit for the holders of traditional knowledge in Madagascar that had already been using that plant for that purpose. But I feel like this treaty would have been to resolve issues such as this, but it doesn't serve that purpose, even though it's attempting to.
Yeah. Very good question. Thank you a lot. I very much like the idea of having a holistic view on the CBD mechanisms and the mechanisms I've described here. And indeed, if one would have more time, it would be interesting to put the 2 pieces together and see how they can work together. I mean, in an ideal world, you could say they are complementary in a way. It makes both sense to say patent applicants should not get proprietary rights on traditional knowledge. This is the White Book Treaty. And then, besides this, to apply the access and benefit sharing mechanism of the CBD, which says if there is use of traditional knowledge and genetic resources, there should be a sharing. And we both know that the access and benefit sharing mechanism, on a substantive level, it looks quite good, but the enforcement side is very weak again. So, and we have debates about this in Germany and Europe, as you may have, I'm sure you have debates in South Africa as well, what the sanctions should be if access and benefit sharing is not respected by parties as it is foreseen in the respective acts. So, as I can tell you from the European situation very much is that parties should enter into agreements, and under those agreements, access and benefit sharing should happen at the end. But what happens if parties do not enter into agreements? And there are some authors who have pleaded for tort claims, but this is a minority opinion about among academics, and we have no legal practice. So it's a mechanism which must be further developed. And it's dysfunctional in a way. And I would compel you to say all these mechanisms should be further developed, and they should be seen as a holistic concept. But I guess, last sentence or to answer you, that one can see these 2 instruments as being complementary.
Thank you very much, Prof. I think we've got 2 last questions from people who are online, and then I'll propose to close because we are really running out of time. So we can have those who are online.
Hi, hello. I'm going to be brief. This is Ana Casanueva. I am not a lawyer. I'm not a patent attorney, but I work in the technology transfer space at UWC. So I actually live the implementation of these things because I support my researchers who are working on indigenous biological resources to patent. And just on what the previous the previous person who asked the question was saying, in South Africa, we are signatories to the CBD as well as the Nagoya Protocol. And because of that, we have a law that protects indigenous biological resources, and that requires that if you are going to be using them or commercializing, then you need to enter into these access and benefit sharing, as well as obviously origin, etc. And because of that, the South African Patent Act had to be amended. So if you're going to file a patent application in South Africa and your subject matter is based on indigenous biological resources with associated traditional knowledge or not, then you have to disclose and you have to actually enter into agreements with the traditional knowledge holders, etc. However, that's in South Africa only. So at the moment, there are a lot of countries that also ratified the Nagoya Protocol, but the patent part has not yet been amended. And as you say, I think this WIPO treaty should be complementary to the Nagoya Protocol and any laws around it. Because there's two aspects. There's indigenous biological resources and the traditional knowledge associated with it, and the intellectual property held within those two, etc. But yeah, I just thought I'd give you the South African side. So when we file a patent application in South Africa, and we do file it in the EPO as well, we do disclose simply because it's an absolute requirement. In South Africa, you will not get your patent granted unless you have disclosed. If you don't disclose, and then it turns out that you did have, I believe that revocation is also not an option, but there might be some fines. We've never done it, don't know, but yeah, not a lawyer. Thanks, that's from my side.
Very interesting remark, and we're running out of time, but there would be a number of issues you're mentioning which would be worth now for further discussion. I'm taking from your comment first that it's very interesting to look in the South African Patent Act to see how disclosure requirements are regulated there. And I'm also taking what you now said at the end, if there is a failure to disclose, what the sanctions are under South African patent law. I was not very clear whether you said it's only fines, which would be, I would say, compatible with the WIPO treaty, or whether there is also a revocation possibility, which then could even mean that the WIPO treaty could be a weakening of the position of traditional knowledge in South Africa, if you have a revocation possibility for the moment, because the WIPO treaty would only foresee this for cases of fraud. So what I'm taking from your comment is, and I'm really grateful for this, I should look into the South African Patent Act on these issues.
So, I stand to be corrected, but I think it's not revocation. I think it's yeah.
Okay.
Is there still another?
One more.
Okay.
Can you ask them to speak?
You can go ahead. The person is with the question online, you can go ahead.
Mr. Babaka.
Mr. Babaka. You can go ahead.
Mr. Babaka, can you hear me?
If you can't hear us, then that brings us to the end of our public lecture. Thank you very much, Professor Axel. Okay, clap them. Interesting presentation. It was really useful. It was eye-opening and impressive. Thank you very much. We hope that the WIPO treaty will really help in terms of patent fraud and biopiracy insofar as traditional knowledge and genetic resources are concerned. And for the participants, thank you very much for attending. For those online and those who were able to do it in person, we do have something next door in the lounge. Please do join us so that we can engage better with our two presenters. Thank you.